the main part of our innovation, which we have to preserve, which we have to secure for a long term. So here I would like to welcome you all on behalf of Asst College of Arts and Commerce. Myself, Assistant Professor Jacintha Nadar, would like to welcome you once again for this session. And for guiding us through the session, we have Honorable Sir Sandesh Sir. He is working as an Assistant Professor in Mead Institute of Management. We are very glad, sir, your presence will guide our students with knowledge, with practical prospect to grow them in every aspect, sir. So thank you so much for your valuable time and accepting our invitation, sir. So here we get started. We'll start with the webinar on Own Your Innovation, Intellectual Property Rights. Up to you, sir. Thank you, sir.
Thank you, Jacintha ma'am, for the kind introduction, and also SST College of Arts, Commerce and Science for the invitation. It is always good to interact with the innovative minds and to talk about IPR. It's always been pleasure for me to discuss this and to get new ideas. Small introduction about me. I'm Sandesh Akre. I'm working as an assistant professor at MIT Institute of Management and currently pursuing PhD in healthcare. And I'm faculty here in operations and supply chain management and systems. So I always deal with the technology, but I'm slightly shifting into healthcare and doing my PhD in healthcare. And then sports is something which is in my agenda for next after my completion of PhD. So I'm looking at so many things and talking about my research work. I have done research in technology like ATM security services and that first research that got accomplished in the Node journal. It is in IEEE Explore as well as it is Scopus indexed and few more research work related to technology as well as management. You can go to that my Google profile and you can check it. So talking why I'm talking about this, because every part there is something to think about it, to talk about it, to discuss about it, and to create about it. So everything about that Bloom's taxonomy will get into it, and ultimately whatever we create that should get into some kind of say property, because we here are creating the property, creating the wealth. Same applies to our intellectual. We human are intelligent than the other animal, and that's why we are creating property. We create property. We own house, land, bungalows, property like money, car, but we don't talk about what our mind is creating. So that should be our intellectual property, and whatever things are included into it that we are going to discuss, and how we are going to protect it, how others should not copy about it, and what things we should take care of it when we talk about the innovation. So how we are going to own our innovation, that we are going to discuss today. You are free to uh, put anything on the comment, so that after the discussion I will just answer. I'll try to answer at my level best. So this is the content, this is the overall flow of today's webinar. First we'll start with the introduction of IPR, intellectual property right. Then we talk about patent, copyright and trademark. And this patent, talking about patent, copyright and trademark, this will be technical. I'll focus on more technicalities rather than the theoretical part. Theoretical part I will just cover into introduction thing, and then I'll go into the technical detail, because I believe rather than going through theory, we should apply it somewhere and get into the process where we will get our intellectual property registered by government of India. Or maybe if you want to go beyond it, outside of government of India, that also we will discuss in our webinar. Then we'll talk about the publication and examination related to patent, copyright and trademark in between. And then I will show you the important links, some links, few links with respect to patent, copyright and trademark. Normally we discuss about it and we don't go beyond it, and we don't get into the practicalities of the process. And many times people feel that this is not our task, we should not get into this. There are someone like attorneys or intellectual property officers, patent officers, copyright officer, trademark officer, they will get into it. But we can also check what is the status and how we should apply it, what are the different aspects that government of India is providing us, what are different facilities and facts are available with us, what are our rights with respect to this, that we are going to discuss, and then conclusion will be there and question answer session will be there. So let's start with this. What is the intellectual property? And so whatever mind creates, whatever mind invents, whatever mind thinks, that becomes our intellectual property. And it is something very closely related with the project management concept. When you talk about project management, there is first stage called as inception. So inception, whatever idea that clicks in your mind, that idea is valid. So whatever you think about it, this can be done. If you think there is gap and this can be done, so at that particular stage, it is valid. But you need to think until at the second stage whether you can take that particular idea into second stage or not. The second stage is realization, whether after the inspection whether that idea can be realized means whether you can put it on the piece of paper and that can be worked, that can be worked upon. That is realization phase. Now this I'll tell you why this realization phase I'll focus more. It is about this particular term has been generalized from the electrical and electronics engineering, where normally we design the circuit and then we provide power supply to it and then check whether that particular thing will give some output or not. If that circuit is not complete, it will not give some output, it will not give output, or it will not give valid output. So that is realization of circuit. But now I'll refer this particular thing with the intellectual property. So in first phase of inception, if you think this can be done, but in second phase if you can realize it, then only you can take it further, right? If I believe that there is a need of constructing a bridge from this end to that end, if that bridge can be put on the piece of paper, or if I can find the blueprint of, if I construct, if I design blueprint of it, then only that can be realized, and that becomes the point of your intellectual property. If you can go from inception to realization, then sure, definitely you need to own that particular property. That becomes your intellectual property. So intellectual property refers to creation of mind. So at that realization phase you are able to create your intellectual property, such as inventions, literary or dramatic work like artistic work, designs, symbols, names, and images that can be used and that can be commercialized. You can use it, you can commercialize it, and you can earn something out of it. You can earn money, not just money, but you can earn fame out of it. You can earn some royalty out of it, not immediate money, but after some time you can own money, you can earn money out of it. That becomes your intellectual property. So intellectual property refers to creation of mind, such as inventions, literary, dramatic, artistic work, designs, symbols, names, images used in the commerce. So as far as this diagram hierarchy is concerned, IP, intellectual property, can be divided into two parts. First is industrial property and second is copyright. So industrial property normally we use in to generate money, to do business out of it. So again, under industrial property you will be able to see there are inventions. So patent. So when you talk about inventions, you need to go for patent, because patent will allow you to use your own invention. Others, they will be able to use it after some time. Normally after 20 years of invention, it will be generalized to the public. So it will not be your own patent, but after some commercializing process, after some say signing MOUs and creating some drafts, you that particular thing can be generally used. So patent, Asani, that is not like patent when you own it, you will be using it for lifetime. After some time, it will be generalized. But in some cases of patent, some case of invention, if it is required for the mankind, human, then it will be technology transferred quickly. So, for example, in terms of now we all have experienced corona pandemic. So in that we have seen how these vaccines are invented and how vaccines are manufactured in lab. So this particular invention, they patented it, but it has to be technologically transferred quickly. It is called as fast technological transfer, FTT. So in some inventions, if it is used for mankind, humans, then and it is very essential for human, then inventions are not restricted up to some time frame. Then comes trademark. Now, trademark is something that can be a logo, that can be a symbol, that can be anything that that any industry will use to generate business out of it. So, trademark is normally a symbol, like we all are aware of McDonald's symbol, we all are aware of Amazon symbol. So all these symbols are representing that particular industry, and using those logos, these industries are generating money out of it. So that's why trademarks are used as a intellectual property. Then comes industrial designs. Now there are different designs are used in industry, and these designs are specifically created. Like if you consider simple bicycle, so bicycle has got different design, different modules are coming together, and it is designed as bicycle. But there are different changes you can do into it, and those can becomes industrial designs. Once upon a time, 15, 10, 20 years ago, cycle with small minute changes, that becomes huge task in industrial designing thing, and many people are changing it like anything. Initially 20, 25 years ago, cycle was just a normal cycle, but then there came changes. People put energy into it, people put their intellectual into it, and they created very variations of cycles only. So intellectual property and the commercial offices regarding the intellectual property, they were flooded with the cycle designs only. So industrial design is huge ask. Initially in India, trademark, invention, and patent, they were handled by only two or three offices like Mumbai, Kolkata, and Delhi offices. But now, 2 3 years ago, because of the huge ask of the registration of intellectual property such as patent, trademark, and industrial designs, trade secret also, I'm talking about it. So now government of India, they have opened so many offices of designing, copywriting, and patenting at Gandhinagar, Bangalore, Hyderabad. Even they are coming at Nagpur. So many other cities now, because Indian government also wants that people in India or students like you, they come up with their idea. Many times we have idea, but we don't put it on the paper. We don't go from the inception to the realization phase. So now it is time, because government of India, PM Modi, they are asking, and other intellectual property stakeholders, they are asking people to get into it, realize your idea, put it on the paper, and then get it under some registration process of patent, trademark, or copyright. So I will be talking about it. I'll be going in detail with respect to this. I'll show all the processes, how to register it, and how to start with this. And once you start with it, then only you will realize the next stage out of it. So I'll try to cover all the stages of this intellectual property registration so that you can own your innovation. Then comes last part is trade secret of this intellectual property. So there are some secrets that will be used by the industry to do some business. Like Coca-Cola, we all know that Coca-Cola has got trade secret, how that Coke is made, and their formula and everything, their ingredients, what they are using, and their entire process. That becomes trade secret. Now they will not disclose it. Even KFC has a trade secret, and they don't share it with others. So that trade secret is also under the industrial property of intellectual property. Then second part of industrial property, that is copyright. Now normally copyright is again, it has got different perspective. Like copyright can be used for the commercialization, copyright can be used by the industry, though I have put it in separate in this hierarchy. Second part of hierarchy, you can check it here. But if you don't want to commercialize it, it is okay. Like we professors, we teachers, we have our own creations. Normally we, when we go in lecture, when we go for teaching in schools and all, we create our own chart, own assignments, and everything. So we are not doing it for the commercializing purpose, we are not doing it for generating money out of it. So but we can make it as a copyright. By default, when you publish book, that becomes copyright. But if I want to protect that intellectual property for my own self myself, then I can put it as a copyright, which cannot be part of an industrial property but my personal property. So this is overall idea of the intellectual property. There are many things associated with it. I have not added music into it. Even nowadays, music, the reels that you are creating, that short stories you are putting on the internet, the social media, one photo that you are clicking, you must have heard about the non-fungible token, fungible tokens, and everything. Even whatever that you put on the a simple, even simple quote that you can put on the social media, that can also be used. If you want to protect these things, you can also protect under the literally and dramatic work. So things are getting more and more expanded nowadays. It may take some other form with respect to AI also. Now they are thinking on it. So under intellectual property, whether you should add AI or not, that is also under funnel now. They are thinking on it. Nowadays we are using AI like anything. So if you create something out of AI, then what should be the intellectual property? Who should own it? Whether that AI engine should own it, or you are going to own it. The person who is giving prompt for that particular AI to generate some property out of it, who will enjoy it? That right, that is under scrutiny. So again, after 1 or 2 years, we will get to know about it. Some now this the chart, the graph that I'm showing on the slide, that may get changed over the time. So these things are getting changed very quickly, and you should keep track of it. A government of India, they want people, they want student at this particular age, keep track of it. I want you to go on internet and check how many intellectual property are getting registered by top 5 countries, which having the good GDPs. Now we all know that India is in the fourth position, and we'll be quickly going to challenge the third position also. So all these top 5 countries like China, USA, India, UK, Germany, how they are filing the intellectual property, who is top among all this. Obviously, China is there at the top, but we are also challenging it, and our government of India want people to get into this particular race and get into the innovation. So let's get into the patent now, as agenda as discussed earlier. Patent, then we'll discuss copyright, and then trademark. So patent is a legal document that grants the owner the exclusive right to make, use, and sell that particular invention. So if you invent something, then you should patent it so that it will be used by and owned by you only. So whatever benefits you want to enjoy out of it, that will be enjoyed by you only. Otherwise, others can also take over it. But it always start with some kind of research. You cannot invent something with fluke. It should be a research work. There should be a proper study about it. And if you are doing it, if you think that I am at the inception phase and I want to realize it, then proper documentation should be done at that phase only, so that you can have the exclusive right of it. Because many other thing, when you are going to discuss, others can also copy it, but as a original inventor, as a person who was there at the inception point, you can only do it better than the other. And that's why I would suggest at this particular point, though patent is a legal document, it always start with the research, and try to publish it somewhere. So I'm of different opinion. People might think that this is my invention, I should not discuss it. Others might copy it, but no problem. You should discuss it. Others won't be able to copy it if it is a proper invention. You must have heard about Thomas Alva Edison. He failed 10,000 times to file 1200 patents. So see the ratio. He failed 10,000 times to file 1200 patents. So around 12% of it. So like that. So you discuss more and more, you write more and more. You start with the inception and you go to the realization phase. So but make a proper research of it, make a proper document of it, and try to publish it. And once you publish it, that becomes your first point of patenting. Though patent says it's a legal document, but if you have published it beforehand, that's become the first point, and that is how it gets compared with registration office when somebody files one patent. And there are many legal hustles with respect to this. Now let's take example of pharma industry. Pharma industry, they are into this patenting like anything in India and any other developed country in the world, because they have small formula, small chemical reactions, and that small changes makes the huge different in their final product. And that's why they will always start with the documentation and publishing it digitally somewhere, so that they will have a legal proof that we did it at first, so this is our own invention. So though patenting, it is a legal document, for the patenting process, it will check who started it, who incepted it, and who started realizing it. And that is how you can get this legal document registered for you, so that you can make use of it. You can make use of your invention. So usually this is for 20 years from that particular date of registration. So when you get the patent, when you get that registration document, legal document, so from that particular day, you will get the 20 years to use your inventions. But it is not like that. As I said earlier, there is something called as fast technological transfer. If you want to transfer it quickly to the human for the well-being of human, it can be transferred. So, in exchange of this right, the owner of patent required publicly disclose the details of inventions in the patent application. So, once it is publicly disclosed, that is why I'm telling you should have some research publication associated with the patent. So when I started working on my research work called, as I told you earlier, there are many research work I've done, but one specific research work I would like to mention about ATM pin generation and verification. That is for security purpose, and that can be implemented in our ATM machine. Thus, that particular research, I thought it should be patented, and that's why I started with publication of that research work. I presented it in IEEE conference, and I'm publishing. I've also already published it in Scopus Index Journal, so that now if I'm going for the commercialization, I can prove all the chronology when it incepted and how I started with it and how I am putting it in the ATM machine, so that in future if somebody wants to use ATM machine and there are some people who don't remember their pin number regularly or passwords regularly, or they keep on changing their password, that time this particular design, this particular invention can be used. So it is important to publicly disclose it, and acceptance should be also there. There are lots of patent registered, lots of inventions are there, but that are not being utilized, that are not being commercialized. And that's why public disclosure as well as public acceptance should be always associated with the patent. Otherwise there will be flood of patents, flood of copyrights, but people, they might not be using it. So that should not happen. So that is also a ratio. They also check with respect to intellectual property, how many intellectual property is being registered in that country, and what is the innovation index of that particular country. We as an India, we as an Indian, we also struggling in this particular aspect, how many patents are getting generated, registered, and how many inventions are getting commercialized in India. Currently that ratio is higher with respect to Israel, because maybe small population and number of patent and copyright they're generating and inventions, that ratio and the commercial, that ratio is higher in that particular country. So we are also getting into it. So now let's talk about the copyright. Like patent, you get a legal document. Similarly, copyright is a type of intellectual property that protects original work of authorship. So as soon as author fixes his work, so as soon as I complete the script of that drama. As soon as I complete my poem, as soon as I complete some post on LinkedIn or some other social media, so that becomes a tangible form of my expression. I need to protect it. As soon as I complete the software, as soon as I complete one model that I created using some AI algorithm, so that author fixes the work in the tangible form, and that becomes that author's own expression. So now this comes under literally dramatic, musical, artistic, and software work. As I told you earlier, AI is also getting included into it, but they are working on it. So copyright allows you to have the ownership of your own tangible work. So, as I told you, this literally dramatic, musical, artistic, this becomes wide variations of copyright that cannot be included into patent. So now you might say, so what can be included in patent and what cannot be included into patent. So if you think as a layman, whatever you design, whatever design you can touch, that you can get into the patenting. But whatever there is in form of soft work, that can be copyrighted. So if I create some say literally work, as I told you earlier, script for drama, then that can be copyrighted. If I write a book, that can be copyrighted. If I write a software, AI code, not AI generated code, but code which use to create AI model, that can be copyrighted. I will show you there are lots of copyrighted being filed by musical industry. Sony Music, they are filing maximum copyright in India, and copywriting may take say around 2 to 3 months also minimum to the 3 4 years also. So that depends upon something. That's something I'm going to discuss, because once you write it, there are many challenges associated with it. Like they might say that this is my original work. Best example of this was in early 2000 yeah 90s. You must have seen Bollywood industry. They were copying movies script, artistic work from the south film industry. So that time there were no legal hassles associated with it. But then in early 2000, they started working on it, and they started filing copyright against it, copyright infringement against it. And then whenever now this, you must have observed Bollywood, they want to copy some dramatic work, they will give due credit to that particular original work, or that particular person will make it copyright, and then only that person can remake that particular work from other languages to Hindi languages or other in other languages. Best example of this currently, Tare Zameen, Sitare Zameen Par, you must have seen the movie, and he is giving due credit to the original work of that dramatic work, and then he has Amir Khan made it in Hindi. So that comes under the copyright. Now these things are not under design. I talked about cycle, example of cycle in the patent. So that's a proper design which you can touch, and copyright is something different, that is comes under the literally dramatic, musical, artistic, and software kind of work. I'm going to show you how to get into patenting thing as well as copyright. Now let's get into trademark. As I discussed earlier, trademark is some representation of your business depending upon which customer will come to you, and you will own that particular liberty, that customer is getting attracted or getting influenced by that particular trademark. So it can be any word, combination of word like phrase, then symbol, design, or a combination of many other things. Maybe nowadays a simple music can also be trademarked. We must have heard during IPL games that particular music comes and that is trademark for the IPL. It was originated in some other country. I remember it was originated in South Africa. Once IPL was played in South Africa, there they used it, and then whatever legal uh, obligations were there, that were completed, and that particular musical theme was brought into India. Now it is for IPL and only. Nobody other can use that particular same music. WWE, this is another example. Many events like NFL, Formula One, sports, English Premier League, Europa, all are any World Cup, soccer, football World Cup, cricket World Cup, they have typical theme. So they use it as a trademark. Even we have heard about the mascot in Olympics and all. So they are also using it as a trademark, but that's a different story. That's not part of trademark, because some, as I talked earlier, if it is used for the mankind and proper use of good health, good use of human, then it will not be considered as an intellectual property. That will be generally accepted terms. So when you talk about general accepted terms, as the topic is generated, like some religious mythological terms cannot be trademarked. I cannot trademark whatever written in Gita or Mahabharat or Ramayana or any other regional books. So that is not, because that is generally accepted now. I cannot use the combination of it also, because now that is generally accepted. So, talking about trademark now, it identifies your goods and services. So, in under trademark, there are different class for good and services. So they have bifurcated goods and services. Uh, Initially, there were around 34 goods and some 10, 15 services. So 1 to 34, this particular class, they assigned for goods under trademarks, and 35 to 49, they these particular classes they assigned for the services. But now services, this has taken some different form altogether, and I could see around 99 kind of 45 to 99, so around 50 services being added under trademark. So these classes they are adding into trademark, and that's why this will take some other format in with introduction of AI also. So now AI generated trademarks or AI classes will be have some different story altogether. You need to keep track of it, because this particular field is changing quickly. Whatever this trademark, patenting, and copywriting, 3 years ago I started dealing with it. I put my own I filed my own patent, and then I started working on it. But since then, it has changed a lot. Every 2 3 months, it will give you some different things together, different work together to work upon, to think upon, and accordingly things are working. And you will see Innovation Council, Indian Innovation Council, and even Indian government, PMO, they are putting more and more efforts into it. They are quick to inherit whatever happening in all around the world, and so that our people in India, they will get benefit out of it, and they will not file any problem registering their intellectual property. So this is with respect to copyright, patent, and trademarks. So now, if you have innovative idea with you and you want to protect it, you want to own it, so how you will go with this? Normally, this patenting will take minimum of 1 year to many years, maybe 10 years. Copyright may take around 45 days to year or 2 year maybe. And this trademark normally takes around 45 days again to many months. But what should you do till then? Do you think you should wait for copyright to be generated, or you should wait till trademark is getting registered, then only you will do business? Nothing like that. You should not wait for long, because in case of pharma, as I give an example earlier, if you have some chemical formula, if you want to do it, patent it or register it at intellectual property, it may take some time. There are some other obligations that to be satisfied. There are other players in market, they might challenge, and then that will go in some tribunal, and then that case will be filed, and then hearing will go on and on and on. In case of copyright, there will be scrutiny process, then re scrutiny process. So it will take time. So what should you do before filing all those things, so that you can start doing business immediately? First of all, whatever innovation, whatever intellectual idea you have generated, you should have abstract ready. So first thing is abstract. So small document of abstract. Every intellectual property, when you go for the registration of it, patent, copyright, or trademark, they will ask for the abstract here. So you need to have abstract ready. Abstract is small document, maybe 1 page of document, hardly 300 to 400 words of document, but it will give the overall idea about the intellectual property. So before filing any intellectual property, get your abstract ready and read it thoroughly. because that's the first impression of your intellectual property. So when your intellectual property will be registered and you start enjoying the benefit out of it, people will get to know from the abstract what exactly it is. I'm going to show you that how that abstract is useful when you're filing the intellectual property, you're going to own that intellectual property. Then second is research work. You need to have proper research work. You need to have a proper literature associated with it. You need to tell what were the gaps and how your innovative idea will address those particular gaps. Because these things are important so that it will be socially accepted. And then if it is not accepted, you will not be able to enjoy benefits out of it, enjoy monetary or other benefit kind of benefits out of it, right? So if I write a poem, if I write a script, it is not socially accepted, then there is no benefit out of it. So better I need to have some kind of research associated with it. Research gives you confidence in your intellectual property work. If you don't do any research and just for sake of it, if you're putting it, there are people who are doing it just to show it for some say audit process, some accreditation process. For that sake, they put it under the say copyright or patenting, but then they don't use it at all. That remains as it is under their name. So you need to have a strong research out of it. I always believe that if it is strong, it has strong research, then it becomes good copyright, good intellectual property. Third is you need to have diagrams associated with it. So as I given one example earlier, we teachers go in classroom with some diagrams, some flowchart, some tables that we create on our own. We study two, three books and we create some abstract kind of it and visual representation out of it. So being in analytical field, I always believe there should be a diagrammatical representation of huge text so that it can be imparted properly to the student. So that's why you need to have diagrams ready with your innovation. And diagrams makes it complete. Diagrams makes that we started with the inception and realization, then diagram makes it realizable. Diagram makes your innovative idea to be realized, to be commercialized at the later stage also. Then fourth, now this is something different. You need to have digital certificate for patenting. If you are filing on your own, even copyright, if you are filing on your own, you need to have digital certificate and e-signature of you. Then only you will be able to do it. Now that makes it different than the normal user of intellectual property than the other people. Like there are attorneys, there are officers, IP officers. They do it on behalf of organization, on behalf of individual. But if you want to do it for yourself, then you need to have digital certificate and e-signature. That's a different story. Digital certificate is not certificate that we digitally scan and put it on the internet. That is not digital certificate. E-signature is not signature that you sign and you take a photograph and you put it. That's not e-signature. That's a different process you need to have for a digital certificate as well as e-signature. Because this e-signature and DC, I will call it as the DC is required when you go for intellectual property registration outside of India. Even for the patent you need to have it, but that can be handled by IP officers or attorneys. But if you want to do it for say other part of the world, then you need to have digital certificate and e-signature, because then there will be traceability. For example, today I have patent of ATM pin generation and verification in India. If same technology is being used in Australia, then I need to go for the international patenting. That time I need to have DC and e-signature ready with me. So you need to be very much equipped with all these five aspects, and then only you should go for the registration of any copyright, patenting, or trademarks. But there are something like if you go in front of judge now with respect to copyright, there will be copyright as well as patenting and trademark. There will be hearing in front of judge, and as we all have seen in the movies that you are not supposed to present your own case in front of judge. There are different terminologies that should be used properly. You hire a lawyer, sorry. Then that particular at that time Here in this case also you need to have attorney who will present your documentation, present your innovative idea and case in front of judge. So in that hearing process you are not supposed to, or maybe you are supposed to be present, but you are not supposed to present that particular thing in front of judge. So in that case you need to have attorney. So many organizations, like I said, pharma industry, they put crores of rupees into this for the intellectual property creation and registration. So they hire these attorneys and officers, patent officer, copyright officers. There is exam. That exam will be conducted. The exam for government of India, and you will, if you clear that particular exam, IP exam, then you will be called as a IP officer. There is separate exam for IP officer and trademark officer. This exam will be conducted in January 2026. So third Sunday of January, there will be IP officers exam, and next Sunday there will be trademark officers examination. So registration is still going on. You can search on internet and you can find it and you can apply it. And there are study material available also, and you can give, there are various centers all over the India. You can find in nearest center and you can appear for that particular examination. If you clear it, you become IP officer, and then you can also file this all IP registration for industry, organization, as well as individual. So that's a different domain altogether. If you want to work, it's a great domain to work upon. You will enjoy working in with innovative minds, and very few people are participating in these particular aspects. If you really want to have a proper work with good income, that's a good source that if you can try it rather than going in traditional way, you can also explore it. So let's get into detail with the patent. Now, when you are filing the patent, there are different forms that you need to submit, and then that process start. First is form number 1. Under form number 1, there is uh, this form gives you general idea. You need to put general information about the applicant. Suppose I am filing the patent, then I'll put my general information, name, address, such as, and then e-certificate, digital certificate. I can put it digital signature. I can e-signature and DC. I can put it here. And it is important because now government of India focuses more and more when if for the female participant, they want female participant to apply for the intellectual property, then because it has been observed that that ratio is very low. So they give special benefit if women applicant is there. And as I mentioned, there is only 1600 rupees fee when you're applying it for form 1, when you're putting your own information. And if women applicant is there, then this patenting process get faster. That has been observed. Again, under form 1, you will put whether you will go for commercialization, whether you will go for international patenting or not. So if you are going for commercialization, if you are going for international patent, that way that process get faster. If you are applying normal, then normally it will take time. The normal patenting takes time. But if you want to go for, if lady is applying, then also this will get faster. If you are going for the international patenting, then also this will get faster. And that's why this form 1 is important. Form 2 is about only intellectual property. So you will put your design thing here, you will draw diagram, you will describe, you will put abstract, some research work. So as I mentioned earlier, we have taken one example of cycle. So if you change some design of cycle, so that design front view, top view, bottom view, side view, every angle view, and other aspect, you will design it, you will draw it, and then you will submit the form 2. So form 2 is all about intellectual property and the design of the patent. It will cost you around 2080. Now this amount is changed. I need to check it, but normally it will not be more than 2080. Then form 9 is optional. Form 9 and form 18, these two forms are optional. Form 9, if you want to publish your patent work in IP journal, you must are aware that you are working as a researcher. If you, then you need to publish your research work in some journal, some good journal. like Scopus Index Journal. Then there are other journals also. So if you want to publish your patent work in IP's Journal of India, then it will be around 2,500. But it will take time and it is optional. If you want to publish it, you can also publish it. I have observed that nowadays they are publishing it before the patent registration of patent is generated. So that's a different thing also. So if you want to publish your work quickly, you can directly go for form number 9. So patenting, registration of patent, that will be come after some time, but your publishing of paper will be quicker as compared to registration of patent. Form number 18, again, it's optional, it's normal, and there are two types of, no, form number 18 is not optional, sorry, but form number 18 is compulsory. There are two types of form number 18, that is normal and express. Examination fee, request for examination fee is 4,000. Under normal, it's a normal process, but if you want to make it quick, like for example pharma industry, they want to quickly deploy that particular tablet in the market, so they will go for the express kind of examination. Examination is nothing but your patenting work, your design will be scrutinized, and there they will put it, they will publish it every Friday. They put examination report. It is called as first examination report, FER they call it as, and every Friday they put it so that others can also refer it. What is that particular patent? What is that design? What is chemical formula they are using it? And then other innovators, if they think that has been copied, they can raise a claim, and then once the claims are raised, then actual innovator or the person who is filing for that particular patent need to address that particular claim. If the claims are properly addressed, then the next process will happen. Otherwise, if the claims are not proper and challenge, the person or organization who challenge that particular claim, they are not finding it satisfactory, they may file complaint against that particular patent, right? So for example, if I file a patent which has been copied from some other patent, then that patent owner may file claim. If I'm not able to answer that claim properly, if it is not satisfactory, then this patent office or that other party may file case against me. So that's why in form 18 there are two types of forms, like normal and express. If you want to go normally, there is no asal that invention you think that is own original, then you can go for the normal. But if you want to do it quickly, or if there is lots of commercialization associated with it, you can go for the express kind of thing. So request for examination, around 4,000 rupees you need to pay. So overall it is not going beyond say 11,000 or so, 12,000 or so. And again, government of India is giving subsidiary out of it for this. If women is filing, there are different concession benefits, so you will get nominal fees. And again, if organization is filing, there is one scheme called as Kapila, Kalam Intellectual Property Awareness Program. That is that Kapila name has been given. So there you get refund also. So refund of around 9,000 rupees is also there. So once you start filing the patenting process, you register yourself for the on the Kapila portal, and then you will also get the benefit out of it. So form 1 to 9 and 18, once you complete, then you can go for the patenting. Now let's talk about copyright. The copyright process is little bit easier, I believe, than the patenting, but again, it is again complicated. So by normal way, there are only three processes you need to complete for copyright: file the application, second, then examination will be there. Normally, they call it as a scrutiny process. Like patenting, if somebody raises the claim that these things are not valid, then again it will be rescanned. It is called as re-scrutiny phase. And once it goes in a re-scrutiny phase, it will take some time. But if it is not in re-scrutiny phase, you will get copyright within 45 to 60 days. And third party is registration. That is the process, copyright process. And as I mentioned earlier, all your documents, abstract, design, diagrams, and other documents like ownership, authorship, these documents are ready, then it is a smooth process. But again claims scrutiny process, if it is goes into it, it will take some time, but maximum 2 years you'll get the copyright. Here I am showing one example of Mickey Mouse. Like Mickey Mouse, it was copyrighted, and 2 years ago, that copyright that is over. Now it is generally accepted. Anybody can use the Mickey Mouse kind of thing. Originally, Mickey Mouse was different, but lately Disney they have made changes, but that was copyrighted. But now you can make change and you can use it. Next is trademark. Similar kind of processes are there, like filing trademark application, then examination report will be generated, and there are different sections under this trademark, like section 9 and section 11. So you need to file and reply accordingly. I'm going to show you trademark also, how these things are different and how you can file it under different classes. There are different classes, around 99 classes nowadays, I guess. So 1 to 39 goods, and 39 onwards, there are services. Lots of services are there, and they're adding more and more services into it on, say, 2 months and 3 months basis. Then filing the reply and notice, then notice will be given to you, and then if you answer every reply and notice properly, you will get the certificate of trademark. So normally same similar kind of process with respect to copyright, but here there are different classes, and those classes and notices reply need to verify. So now let's get into this. As I talked about patent, now uh, just let me show you again this patent. Form number 9, publication of the journal, and form 18, request for examination. So how these things are done, I'll just show you. I'll just click on this link. This link is ip.ipindia.gov.in, IP journal and journal patent. So how you can publish the patent work in the IP journal. You can find this link easily. You can Google it and you can go to the IP journal publication. It will take some time because on every Friday there will be examination report generated, and using this examination report there will be claims. There are claims raised, and these claims you need to address regularly. It will take some time to open. So you need to keep track of it. Government and many organizations, they employ people to check it regularly, because as example of pharma industry, they put crores of rupees into it, and some claims are raised, and again their entire effort, their research and development work, the work of around 1 to 2 year, that gets destroyed if claims are raised. If some other organization they raise claim that this is my original work and they are doing it for their purpose, so that goes in hearing process, and it will take lots of time, lots of money goes into it. And that's why you need to keep track of what is happening in other industry. You are working for one organization, that doesn't mean you will only work for that organization. If you are innovator or entrepreneur, you need to keep track of what is happening in the world, what is happening in the other organization as well as competitor. People are keeping track of what other competitors are doing. It is taking some time. Let me try. Let me just close this presentation. It might work. Is it visible?
Yes, sir, it's really good.
So this is the journal, IP journal, and you will be able to see date of publication and date of availability. So till September, sorry, this 5th September, they have given the publication, and as you will see, there are different parts of it. Part 5 is only last part. Normally, they will keep it for designs only. Let's get into designs. Let's see what are the latest designs that are filed for the patenting. So in this journal, there will be a research work or there would be abstract, but there will be lots of design that we can go through and we can check what people are doing around, what organizations are doing all around India. So this is the introduction of that patent. You will see lots of work. This is patent CBR number. First column. You will find this particular number is called CBR number in case of patent. In case of patent, it is CBR. It is cash book receipt number. For copyright, it is diary number. Similarly, there are classes number. There are trademark registration number in case of trademark. So this is design CBR number, and if you scroll down now, let's check this. This is the first in this class 5. This is design number class 1101. Some Sashi Calcutta LLP, they have filed it, and this is for jewelry set. So this jewelry design they are patenting, and this is some mechanical engineer RMK college, they have filed it from Tamil Chennai, and this is transplanter and harvester machine. So some design they are created. Then there is beach clean device from now this is individual work. Ria Francis from Chembur, she has filed it for beach cleaning process. And then here also we can see one table, well, just table, simple table, but the design is changed. The horse design is there. Now table we use it, but simple table with some change in design, it is filed for the patent. Now this pull up bar set we are using it, but now they have designed, they have redesigned it, ergonomically designed, and that has been filed. So like this, these are the various design, you can check it, and even you will get idea out of it. And if your innovation and inception and these ideas are clicked, then you can also do various kind of changes into it. This is with respect to uh, patent. Now let's get into copyright also. So copyright, you will see ROCs, registration of certificate. So monthly they will give it. So August 2025, you can download the ROC and you will see how many copyright are being registered. So this is September, starting of September. So till August they will publish it. So you can search it. Here you will see the applicant's name, categories, literally dramatic, computer software, like Indian Institute of Technology, Kharagpur, they have a copyrighted web learning system for children with dyslexia and learn sentence reading. So this software they have copyrighted. I will just check my institute or other institute somewhere from. You will see here many engineering colleges, management colleges are applying for it. Like here, Institute of Engineering and Management from Wadhwani, professors Divya Pandey and Jaya Chobe, they are applying for AI-driven mental health monitoring and support application. So this is again, I believe this is literally and dramatic. They are just putting how to do it. This is not a software, but that can also be copyrighted. This is with respect to copyright. Now let's get into the trademark. So trademark, again, I'm just showing it for Indian government first, and then let's go to the World Intellectual Property Office. So trademark, as you will see, the trademark will be publication will be shown as a class. So class 1 to 30, class 31 to 99. So notice as well as class you can see here. So notice you need to address those notice, then only trademark will be generated. Otherwise it won't generate it. So you will see up to yesterday they are putting it. So every week they are putting it, because trademark there will be huge applications for trademarks as compared to copyright and patent. So it will take some time because there would be many people applicant for the trademarks, because trademark directly symbolizes your business, and people find it very easy once you have a trademark and to find your business. So it is taking some time, but I will share those links with you. You can find it, and how the small changes will make it different, make the difference. You can check the classes like class 1 to 34, what classes are there. Normally class 1 to 34 are product, and 35 onwards are services. So around 60, around 55 services are categorized under Indian IPL, Indian IP trademark. So it is taking some time. I will show you. Meanwhile, your questions are there. You can just put it on the chat box. So this is it from my side. It is getting loaded. I will just show you. But if you have questions, please put it on the chat box. See, now this is there. Vyapar Chinna Patrika Trademarks Journal, like copyright, like patent journal. We have trademarks journal also. So even your trademark is registered here, it is valid. You can now. It is in Ahmedabad. This office is newly opened in Ahmedabad, Gift City. They are opening it. Initially, it was in Kolkata. So this is first trademark that is there applied on this in this month. Navratna, something that written in Bengali language, I believe. This is True Seal. They applied it. This is they applied. This is something with respect to botanical thing, gardening thing, applied from Gachibowli, Hyderabad. Now this boss foliar applications. Now some seaweed based on biostimulant, they are using it. So if you want to do some business, then you need to register your trademark. This algorithm, these again biofertilizers, they are registering it. So in this particular season, you will find that many fertilizers, ferticame, bio industry fertilizers, chemical products, agriculture, they are filing the trademarks. Obviously, it's the monsoon season going on, and that's why they are applying it. So here you will get idea. What I'm trying to say here, you will get idea about what is happening in the industry, and how you, as an innovator, as an entrepreneur, how you will keep pace with what is happening all around the world. So this is with respect to India. There is something WIPO, World Intellectual Property Organization, and here the link is also there. I will just share it with you, and again you will find it. You just put those link and you will find it how the things are happening all over the world. If you want to go for the international international intellectual property registration, you have to regularly visit to WIPO. So here, same process, industrial design, and what are the counts? The Africa, you can just go by the location, geographical area, and you will see how many intellectual property are being filed or registered. Africa, Asia, Oceania, kind of thing. I'll share those links. I'll put these links in the chat box, and you can also refer this. Okay, so this is from my side. Now I'll wait for your questions if there are any. Just put it on the chat box. Jessica ma'am, Jacintha ma'am, if you can help me with the if there are any questions.
Yeah. So I think one question has arisen from the student who was attending from live YouTube stream. He has asked the question which has been already answered, addressed by you. What is the process to file the copyright? So I think that has been systematically explained in
Yes, yes,
previous time.
yes.
That one question was there. Apart from that, if anyone still wants to ask any question, it's open to you all. Kindly text in the chat box and it will be asked on your behalf and it will be answered. We'll just wait for a few minutes.
Yes, ma'am. I have supplied the link also. You can also go through. You can
Yes, sir.
copy and paste it on the live stream, please.
Yes, sir. Sure, sure, sure. I think no more questions. So we are at
Okay.
the end of the session.
Thank you, ma'am. Thanks.
Yeah. So, as we all know, as every beginning has the end, so does this session. And it has been eye opening for all of us. Thank you, sir, for your valuable insight and valuable lessons. The practical perspective regarding examination, regarding websites, regarding procedures, regarding payment has been very crystal clear to all the listeners. Thank you so much from the bottom of my heart for accepting our invitation and making this day, this session more practical, uh, more knowledgeable, more informative to every one of us. Thank you, sir.
Thank you, ma'am.
Thank you, all the participants, for this session, attending this session. I hope in coming days you will own your innovations through the power of intellectual property rights. And I would like to end this session extending my heartfelt thanks to our resource person, Sandesh sir, for his valuable time and his experience on sharing the detailed description about all the minor points, even how to gain the idea, how to register step by step. So we are very
My
thankful to you
pleasure.
for the session, sir. And I would like to take this moment to thank our founder, principal of our college, Dr. Varshani sir, for encouraging us to have such session for students to gain practical knowledge. And I would like to extend my heartfelt thanks for our IQC coordinator, uh, Dr. Varshani ma'am, for encouraging us and motivating us to have such sessions for children to grow and to have this practical knowledge and to enlarge their perspective in every domain of the academics. So thank you, everyone. Thank you. Thank you, sir. That's all for the day. God bless you all.
Thank you, ma'am.